Good morning. Welcome to the Sparks Justice Court. This is the time set for initial appearances and arraignments. In a few minutes, each of you will be appearing before a judge by video or in person. If this is the first time you have appeared in court in your case, you will be formally advised of the charges against you in your complaint. The judge will be asking you questions to make sure that you understand the accusations against you, so please have your complaint in hand when you come forward to appear. If you are here because you were charged with a felony or a gross misdemeanor, these comments apply to you. This is your initial appearance in court. You will be advised of the charges against you in the complaint, and a mandatory status conference will be set within the next 7 days. You cannot and will not enter a plea today. If your attorney and the district attorney are unable to negotiate the case, it will be set for a preliminary hearing. At the time of the preliminary hearing, the state will be required to show probable cause to believe that the offense or offenses with which you are charged were committed and that you were the person who committed them. If that burden of proof is met by the state, you will be bound over for trial to the Second Judicial District Court, or you will be asked to enter a plea of guilty, no contest, or not guilty to the charges set forth in your complaint. You have the right to have an attorney represent you in all stages of these proceedings. If you cannot afford an attorney, the judge will appoint one to represent you. Many of you have already met with court services and filled out an application for an appointment of an attorney. You also have a right to remain silent. You cannot be required to make any statement, but any statement made by you today may be used against you. If you are here because you were charged with a misdemeanor or a citation and have not previously appeared on those charges, these comments apply to you. At this arraignment, you will be advised of the charges against you in your complaint or citation. You have a right at this time to enter a plea of guilty, no contest, or not guilty, or to take additional time in which to enter a plea at all, in which case the judge has a right to enter a not guilty plea on your behalf. You have the following constitutional rights in justice court. The right to have an attorney represent you. If the district attorney has indicated that they will be seeking jail time, or if conviction of the particular crime has mandatory jail time, and an attorney will be appointed to represent you if you are unable to afford one. Otherwise, you can hire an attorney at your own expense. The judge may also grant a brief continuance if you desire to have an attorney represent you. The right to a speedy trial. The right to require the state to prove each charge against you beyond a reasonable doubt. The right to confront or question all witnesses against you. The right to subpoena witnesses to testify on your behalf and compel their attendance. And the right to remain silent and not testify at trial. The fact that you remain silent cannot be used against you. If you have pled guilty or no contest, you are giving up all of these constitutional rights, however. You should also be aware you have the right to represent yourself if you choose. There are dangers and disadvantages in doing so, including, but not limited to, the facts that self-representation is often unwise, and a defendant may conduct a defense to his or her own detriment. A self-represented defendant is responsible for knowing and complying with the same procedural rules as lawyers and cannot expect help from the judge in complying with these rules. A self-represented defendant will not be allowed to complain on appeal about the competency or effectiveness of his own representation. If you plead or are found guilty of a misdemeanor, the maximum penalty is up to 6 months in the county jail and or up to a $1,000 fine plus additional monetary assessments and fees imposed by law. The judge is free to impose any penalty up to those limits as long as the judge believes the sentence to be fair. It is unlikely that jail time will be imposed unless required. However, if the matter involves facts that are aggravated, jail time may be imposed. Should that occur, you will be advised that the judge intends to impose jail time before he lets you enter a plea. You may then request a continuance, and if appropriate, appointment of an attorney to represent you, or you may retain your own counsel. If you enter a plea of guilty, that means you are admitting to your guilt, and the judge can sentence you today. You may also plead no contest. A no contest plea is normally reserved for cases with personal injury or property damage resulting from your conduct. A no contest plea means that you are not admitting guilt, but you are saying you do not wish to contest the charges against you because you believe the state would prove you guilty beyond a reasonable doubt. In that case, the judge would make a finding of guilt and you will be sentenced today. If you enter a plea of not guilty today, you will be required to attend a pretrial conference with your attorney, if one has been appointed or retained, and the Deputy District Attorney from the Washoe County District Attorney's Office. If you wish to do so, you may discuss the merits and the facts of the case at that time in an attempt to resolve your case. If the case is not resolved at the pretrial conference, it will be set for trial, and you will then be able to exercise each of the constitutional rights which were previously described. If you are here for any other reason other than those I have just described, the judge will discuss those reasons with you and to determine what should be done in your case at the time you appear. Thank you for your attention.